Hello, I'm Carol Wick, the CEO of Harbor House of Central Florida. If you're watching this video, it's probably because you or someone you love is in an abusive relationship and may be in danger. We hope this video helps you learn more about our services and helps ease some of your concerns about seeking help. At Harbor House of Central Florida, our court advocates assist those who are experiencing abuse by developing a plan for safety and helping them through the injunction process. Your safety is our #1 priority, which is why our offices are located in downtown Orlando at the Orange County Courthouse at 425 North Orange Avenue in Suite 520. The parking garage is located right in front of the main building, and our office is open during courthouse hours. Harbor House advocates are dedicated to assist anyone who may be experiencing abuse by guiding them through the legal process. An injunction for protection is a document that can legally protect someone from abuse. A petition for an injunction may be filed if you're the victim of abuse or if you have cause to believe that you may become the victim of abuse. Injunctions specifically address whether or not the person you are afraid of can go within a certain distance of you or have any contact with you whatsoever. Injunctions for protection ensure that the person you file against cannot legally contact you for any reason. If your injunction request is granted by a judge, the person would be prevented from going within 500 feet of you and any address that you would like to include. Also, the person would not be allowed to contact you for any reason in any way, including telephone contact, email, social networking sites, through the mail, or even through another person. When you file for an injunction for protection, you will be identified as the petitioner. The person you're filing against will be identified as the respondent. To file for an injunction for protection, you must go to the Orange County Courthouse. The courthouse hours are from 7:30 a.m. to 5 p.m. Monday through Friday. The filing takes time to process, so we recommend that you arrive before 3 p.m. to allow the judge enough time to review your case. You may go to the Harbor House office in room 520 when you arrive for assistance through this process. The advocate will also discuss with you a plan to stay safe and about services that may be available to you. After the paperwork has been filed, the judge will review the case and make a decision based on the information you have provided in your petition. The judge can order the petition granted, denied, or set the case for a hearing without granting a temporary injunction. If the petition is granted or set for a hearing, you will need to return to the courthouse in 2 weeks for a hearing on the final injunction. In the meantime, the person that you filed the paperwork against needs to be served by law enforcement officers. If the order is violated, you need to call 911 immediately and report it to the police. On the day of your hearing, you'll be asked to arrive at the courthouse and will be placed in a separate waiting room different from the person you filed against to ensure your safety. If you have any other safety concerns at the courthouse, you may speak to your advocate or to the courthouse deputies. The person you're filing against may attend the hearing to offer a response to the court about your request for protection. You will have a Harbor House advocate accompany you to court on the day of your hearing who will guide you through the court process and serve as a support system. If you have any questions or concerns prior to the court date, you can contact an advocate to discuss your case. When it's time for your hearing, the judge will call you into the courtroom and you'll be asked to discuss the details of your case. In the courtroom, there will be deputies, court staff, a Harbor House advocate, and you may choose to bring an attorney if you wish. The judge will also ask you to provide evidence to support your case. If you have any evidence, you will need to bring it with you to the hearing. Some items that may be entered into evidence include documentation regarding you and your children, police reports, photos of injuries, medical records of injuries, notes of dates and times of incidents, phone records, and witnesses to the incidents. A judge will ask you and the other party a few questions about your case. As long as the injunction has been served by a police officer, you will have a hearing. After the judge is finished asking questions, he will make a decision on the final injunction. You may also have the opportunity to discuss issues regarding child custody, property issues, and referrals to supportive services such as batterer's intervention, which is counseling for your abuser. The judge will grant the final order for a specific amount of time. At any point in time after the hearing, you may ask the court to make changes to the injunction. It is important for you to keep a copy of the injunction with you at all times. Just like the temporary, if this injunction is violated, you need to call 911 immediately and report it to the police. If you have any questions, you may contact a court advocate at 407-836-2001 or our 24-hour hotline at 1-800-500-1119.